Welcome to Class 6 of the Mr. Cannabis Law coursework. Today we're going to be talking about intellectual property. Now, for any business that's starting, it's so important that you properly protect your intellectual property, and that really includes trademarks, patents, trade secrets, and copyrights. And we're going to be going over all of those today, and the coursework goes through all of that in great detail. But if you're representing a company that's building a brand, they need to make sure that they're trying to protect it with a trademark. If you're representing a client that's developing a proprietary process or has other confidential proprietary information they want to protect, you're going to want to make sure that you advise them about patents or trade secrets. And similarly, if there's any sort of work or art, you may want to look at also the copyright side. So we're going to be going over all that today, and we're also going to be obviously focusing on where these particular areas are complicated for cannabis companies. So, trademarks. The big difference between a trademark and a patent is that a trademark needs to be legal activity. Trademark needs to be legal activity, whereas a patent does not need to be legal activity, because a patent, it's really a negative right. You're really excluding someone from doing something. It's not a positive right, it's a negative right. So technically on the patent side, does not need to be legal. So on the trademark side, how does this get complicated? Well, I break this out into two different sections. So if you want nationwide protection for a trademark, you apply with the USPTO office, right? If you want just in a particular state, in a geographic region, you could also apply within a particular state for trademark protection. So there's the USPTO, which gives you national protection. There's state level trademarks, and then there's also common law trademark protection. So actually, if you file nothing at a federal or state level, there are actually some protections you get just from common law. So it's very important to understand all those opportunities from federal, state to common law to really advise your client on what they should do. So the main challenge on the marijuana side is that it's illegal under the Controlled Substances Act, right? You can't grow, process, dispense. It is not illegal to sell a t-shirt with the name of your brand on it. It's not illegal to provide educational materials with your brand on it, right? So what you see in the marijuana industry is people obtaining, or companies obtaining, a trademark for the legal activity. So for example, if you're MindMed let's say you're TrueLeaf, and you want to protect that brand, you will not be able to protect that brand with the USPTO in a category for selling marijuana products, but you will be able to pick a class like apparel to protect your trademark on clothing. You will be provided to find the class that protects your particular name, TrueLeaf, for educational materials or anything else that isn't involved with illegal activity. So that's kind of a loophole of sorts for some of these marijuana companies. They will go for trademarks, but it's not on their products. It's not on selling their products. It's not within those classes that are all illegal activities. It is within the legal activities that they do, obviously with the hopes that once it goes federally legal, they'll be able to more easily apply for a trademark within those other classes that are currently illegal, but hopefully legal into the future. The other thing that marijuana companies will do is they'll actually apply within the state, right? Because USPTO applies federal law. Marijuana is illegal from federal law. But if you want to apply within Florida, for example, for a trademark, it's not illegal in Florida. So what a lot of marijuana companies will do is they will file with the USPTO office for the legal activities, and then they'll file within various states that they're operating in for the illegal activities. That's one of the things that you need to keep in mind, and it gets much more complex as you start getting into office actions with the USPTO. Now on the hemp side, we went through in previous classes that hemp is federally legal However, this is very, very important. It's federally legal, but the 2018 Farm Bill, like we discussed in previous classes, specifically preserves the authority to the FDA to regulate hemp products for food, dietary supplements, drugs, cosmetics, all the things that the FDA has authority for. And the FDA has taken the position that CBD is illegal in food or when marketed as a dietary supplement. So the USPTO has probably rejected hundreds of applications for CBD brands that have applied for licenses for trademark with the USPTO and listed within a class of products that are food or dietary supplements, and the USPTO every single time will reject that application because trademarks at a USPTO level need to be legal activity. The FDA still considers CBD to be an illegal product. So really, really important that you don't just get lazy and say, oh, well, this company is not in the marijuana side, they're on the hemp side, so I have nothing to worry about. You still need to be very careful because the FDA still considers CBD to be illegal. Now, moving on to the next slide, what we're going to go over is patents. So the good news about patents, what makes trademarks so complicated is that trademarks need to be for legal activities. Patents don't need to be for legal activities. So you have various different types of patents you could apply for within the cannabis space. There's plant patents, there's utility patents, and then there's also design patents. Now, patents become extremely, extremely important in the cannabis industry, but one area that there is a little bit of a wrinkle and where there's some complication is the actual enforcement of patents. If you were to actually go to federal court and try to actually enforce your patent, the federal court could probably provide you with an injunction. But since marijuana is federally illegal, and let's say you have a patent on a particular process of manufacturing it, and some other company is infringing on that patent and you sue them in federal court, that court system will likely, they could give an injunction, but whether that court would be able to grant a remedy of damages, essentially what that court would be doing is telling a federally illegal business to give money to another federally illegal business for a patent of a federally illegal activity. So most likely, I think the court system would be able to do that, but that's just one of the wrinkles that you have to deal with on the patent side. Now, just as a side note, in the psychedelic industry, we talked about really right now psychedelics are mainly they're going to be a biotech play. So psychedelic drug compounds are being taken through drug development. And so there is a patent grab right now on the various compounds. Now, you cannot patent a natural compound. That's very important to understand. You cannot just patent cannabis. You can't patent psilocybin. You can't patent peyote. You can't patent any of these compounds that are naturally occurring. So what happens is these companies create analogs, or they create different versions of these compounds, or the method of producing those compounds, and they will patent those. So the psychedelic industry has really become a breeding ground for patents, and there's attorneys right now that are out there that are exclusively working within the psychedelic space and the patent space. So very interesting space. If you are a patent attorney, you should definitely pay attention to what's going on within the psychedelic space. So moving on to the next slide, trade secret. So a trade secret refers to information including formulas, programs, techniques, could be all sorts of different stuff that derive economic value by not being generally known to the public or to competitors in the industry who can take advantage of the information. So really, if you have some sort of proprietary information, you could file a patent. But the thing about the patent is that a patent makes it public to the world. So a lot of companies don't want the world to know what they're doing. So what they'll do is they'll just keep it a trade secret. But if you really want to keep something a trade secret, there's certain steps you need to take, right? You need to have your employees sign confidentiality agreements. You need to take the steps required to keep this a secret. If you claim that your production process is a secret, yet you let people in and out, no problem, without signing in or out, and everyone, the whole world could come into your facility to see it, you're going to have a very hard argument that particular process is also a trade secret. So this is just some general trade secret law, and I'm sure if you're watching this and you're an attorney, you're probably relatively familiar with trade secrets. But what is complicated in the cannabis industry is enforcing trade secrets, because once again, illegal activities, if you have a production process that you're trying to keep as a trade secret, and you have an employee that is infringing or stealing that trade secret and going to your competitor to use that manufacturing process, enforcing that within a court system is going to be very, very complicated. Not to say you can't do it, but different courts will probably come out differently on the enforceability of a trade secret for a cannabis-related trade secret. So moving on to the next slide, we have copyrights. I'm not going to spend a whole lot of time on this. You guys can read up on what a copyright is. There's really not much complications when it comes to copyrights in cannabis. Copyrights are really just original works of authorships, including literary, dramatic, musical, or artistic works. We see plenty of copyrights in the cannabis industry, and generally there's not going to be much issue with those copyrights. So moving on to the next slide, we'll be going over the do's and the don'ts. So do realize that patents are the most popular form of intellectual property within the cannabis industry. A variety of cannabis products can receive protection, such as marijuana strains, cultivars created using unique operating procedures and unique product designs. Do remember that there are a variety of ways a marijuana business can protect its brands, slogans, logos, and designs used in commerce. Do not think just because marijuana is illegal, you cannot get a trademark. There are classes within the USPTO filings that you can use to protect your brand. So do protect proprietary information by requiring all directors and employees to sign confidentiality agreements. You really want to make sure if you're trying to protect something as a trade secret, you're taking the necessary steps. Very important you advise your client on the front end on what they need to do for something to really be classified as a trade secret. Because what happens all the time is someone ends up stealing the trade secret, then they come to their attorney, say we want to sue them for stealing our trade secret. But what happens is then the attorney looks into the steps they've taken to keep it a secret, and the company has not required the employee to sign a confidentiality agreement or proprietary information agreement or anything like that. They haven't taken the steps required to make it, to have it constituted as a trade secret. So very important as an attorney to try to get involved on the front end to know what the operations are for your clients so that you could properly advise them on the steps they need to take to ensure that that is actually considered a trade secret by the courts. The don'ts. So don't forget that words used or inventions of cannabis products, processes, designs, and works can also receive trademark, copyright, and trade secret protection. Don't forget marijuana items and services cannot receive federal trademark protection, right? So the products and the services for the cannabis industry, assuming they're illegal, cannot get national trademark protection. Don't forget that an operator needs to take active steps to prevent proprietary information from disclosure if you really want to protect this as a trade secret. So lots of really good information. We talked about trademarks, patents, trade secrets, copyrights. The main thing here is about the federal illegality makes things very complicated, mainly from a trademark perspective for both marijuana and hemp, because FDA deems CBD to be illegal if used in a food or as a dietary supplement. So